Good evening. Today is Saturday the 8th of October 2016, and today I'm just doing a presentation video just to explain the outline of some of my submissions filed with the Court of Appeal in respect of the Sajo Oyang appeal. So this appeal involves the Sajo Oyang Corporation, who is the appellant, the Ministry of Primary Industries, who is the second respondent, and Rudy Hardino and 25 other foreign fishermen from New Zealand, who are the second respondents. I represent the second respondents. The lead second respondent there is a fisherman from a sunken vessel, Oyang 70, that sank in New Zealand waters, who has been unpaid since 2009. And there are also another fisherman from Oyang 70 and 24 fishermen from Oyang 77. So what is this case is about? In terms of my submissions, it's set out in a folder that has 10 subsections and 2 appendixes. There is a word and page limit imposed by the New Zealand Court of Appeal for appeal, and it can't be more than 30 pages with a cover sheet, so that's 29 pages. So in respect of what's going on, so as I was saying, the second respondents are Indonesian foreign nationals. They were all employed in New Zealand on New Zealand work permits as foreign fishing crew, and these 26 people worked on Oyang 70 and Oyang 77. These vessels, Oyang 70 and Oyang 77, were owned by a company called Sajo Oyang Corporation, which is a South Korean corporation. And these vessels were in New Zealand fishing. Oyang 70 sank, and that sank on the 8th of August 2010. 6 people died. Oyang 75 was forfeited to the New Zealand government, the Crown, via the Ministry of Primary Industries, who prosecuted them for fishing crimes, on the 29th of September 2012, when its captain was convicted for the fishing crimes. Oyang 75 is a vessel worth US 7.5 to 8 million approximately. That's the last valuation that I've seen. That was obtained under the Official Information Act, so it is quite old. We don't have a current valuation on it. That has not been disclosed by the Sajo Oyang Corporation or by the Ministry of Primary Industries. The Oyang 77 vessel was forfeited to the Crown on the 3rd of September 2014 for Fishery Act offences, when its captain was also convicted for fishing crimes. And that vessel has an estimated value of New Zealand $1.5 million. Again, it's not an up-to-date valuation. It was one obtained under the Official Information Act from 2009. So the second respondents, which is the 26 fishermen, are all claiming unpaid wages for working on vessels owned by the Sajo Oyang Corporation, and they're seeking for them to be paid out of the forfeited fishing vessels. The issue in the appeal that's taking place in the Court of Appeal in Wellington in New Zealand, which starts on Wednesday the 12th of October 2016, involves statutory interpretation of section 256 round brackets 1 round brackets C of the Fisheries Act 1996, and that is whether the fishing crew can claim relief from the effects of forfeiture for their unpaid wages over a sister ship, that sister ship being Oyang 75. A sister ship is a ship that is owned by the company that the people work for, but they didn't work on that particular ship. And remember, I've got people that work on another ship that sank and on another ship that was also forfeited, but that other ship that was forfeited is not very good condition. It's very old, so it's not worth enough to pay their wages. So on selling it and paying the cost of the prosecution, the cost of the investigation, it's not going to be enough to pay the wages. So collectively, both vessels need to be sold, and Oyang 75 is the best vessel, as far as we can tell, that would have the best options of paying the crew their outstanding wages. So forfeiture occurs when there's been a conviction for criminal offending under certain offences of the Fisheries Act. When a crew have unpaid wages, they have something called a maritime lien. It adheres to the ship, and it can also be claimed over a sister ship, so that you can make an in-rem claim over a vessel that's owned by your employer or by somebody else who buys the vessel off the employer. And that just stays there forever until you've paid. The exception is that if the vessel gets forfeited to the Crown, the Crown takes that vessel free and clear of all encumbrances, which means that the fishermen lose their maritime lien over the sister ship. So if you worked on that ship, they'll say you had the maritime lien over it. Otherwise, you're making a claim over a sister ship, and that's got a slightly different name. They'd say you'd had a slightly lower priority. The people who worked on that ship should get paid out first, so you're more like a statutory lien, which is up there in priority but slightly less priority than if you worked on the vessel. So because the vessels Oyang 75 and Oyang 77 were forfeited by the Crown, that vessel vests completely in the Crown now, and no action in rem, which is no action over the vessel itself, can be taken against the Crown. So to remedy this situation, the government has passed in 2002 some legislation that took effect on the 18th of September 2002 called the Fisheries Foreign Fishing Crew Amendment Act. And that amended Section 256 of the Fisheries Act. Prior to that, what happened is when the vessels got forfeited, if you wanted relief from forfeiture, there wasn't anything you could do about it. You had to go and ask the Ministry of Fisheries and ask the Minister if he could help you out. Now there's an actual whole process designed to deal with vessels that get forfeited and to help the fishermen if they haven't been paid, and also to allow the owners to apply for relief from forfeiture and other people that might fit within this section. So this section is section 256 of the Act, and I sort of set it out in the submissions. I'll read that to you. So section 256 says that it relates to provisions relating to forfeit property. Subsection 1 says, unless the context otherwise requires, forfeit property means any fish and any proceeds from the sale of fish, or B, this is what's important to us, subsection B, property used in the commission of an offence, or subsection C, quota, and it's forfeited to the Crown under sections 255A to 255D, which is, when there's been these fisheries offences. So that's the definition of forfeit property. We come in because we are arguing that we can fit in under section 256(1)B, that the ship was property used in the commission of the crime, therefore that's forfeit property. The next part of the definition relates to the word interest. What does interest mean? And there's 3 subsections that define what an interest might be in this forfeit property. So the first type of interest under subsection A is the case of quota. So that's about fish. We don't have an interest in fish. Subsection B says, well, in the case of a foreign fishing vessel, comma, a foreign-owned New Zealand fishing vessel, comma, or a foreign operated fish carrier, there are 3 types of interest you could have. 1, little round brackets I, ownership, i.e. you own the fishing vessel. It has to be a foreign one, okay? It only applies to foreign vessels, this section. Or you could have in the subsection little 2, an interest as determined by the Employment Relations Authority or any court that any fishing crew have in unpaid wages. So that is the fishing crew. Do they have an interest in unpaid wages? And we already had a court case about that. Sajo Oyang Corporation had said, oh well, you have to go to the Employment Relations Authority first, get your wages determined, and that has to be happened before the vessels are forfeited. And then if the vessels happen to be forfeited for fishing crimes and your unpaid wages have been sort of decided by the employment court, then you can pop along to the forfeiture court and ask for relief from forfeiture then. We said, load of rubbish, Sajo Oyang Corporation. We don't have to go to the ERA first. We can go straight to the forfeiture court and ask for relief from forfeiture. We had a big hearing about that on the 16th of April 2015 at the Christchurch District Court with Judge Keller, which we succeeded on, and Sajo Oyang Corporation appealed. That went to the Auckland, so the Christchurch High Court on the 8th of September 2015 with a decision from Justice Davidson on 18 December 2015 that no, we don't have to go to the ERA first to have the wages determined, that the forfeiture court is able to determine the amount of the outstanding wages. There was a huge drama also at that appeal court about what does any court mean, because the Sajo Oyang Corporation was saying, oh well, that's the Admiralty Court, go off to Admiralty Court and have your wages determined first before you can apply to the forfeiture court for relief. And they also were saying, oh yes, by the way, you must have those wages determined before the vessels got forfeited, before you apply for the relief. And the High Court said, no, that's fine, you can apply in the forfeiture court. And the drama over that seems to have stopped because the Sajo Oyang Corporation hasn't appealed that point to the Court of Appeal. The third type of interest that you could have, going back to talking about that, in a foreign fishing vessel under Section 256 is, and this is what the issue is here, is, sorry folks, is in the case of other forfeit property, a legal or equitable interest in that forfeit property that existed at the time of the forfeiture, but does not include any interest, brackets, other than an interest referred to in paragraph B, that's the one I just read to you, in a foreign vessel, a foreign-owned New Zealand fishing vessel, or a foreign-owned operated fish carrier. So these are the key words. Other forfeit property, so that leads us, we're having an argument about lots of stupid things in this case. What is other forfeit property? What does the word other mean? What is a legal and equitable interest in that other forfeit property? Did it exist at the time of forfeiture? And it's not allowed to include anything except what was listed above, which is an interest in ownership, or an interest in unpaid fishing crew wages, or an interest in costs incurred by a third party other than an employer in relation to providing for the support and repatriation of foreign crew employed on the vessel. So it seems to me to be sort of a slightly circular. So the central question in this appeal, requiring determination in the Court of Appeal on this hearing in October 2015, is whether the fishing crew employed on a foreign fishing vessel in New Zealand by an employer in the beneficial ownership of a foreign fishing vessel or vessels immediately before the forfeiture to the Crown for Fisheries Act offences have an interest in a sistership as other forfeit property, and whether they may apply under Section 2561 round brackets C of the Act to seek relief from the effects of forfeiture to obtain their unpaid wages. So the term sistership is meaning to be a ship that was owned by their employer, but they didn't work on that particular one at the time. So there are a number of statutory interpretation issues in dispute between the parties of this appeal. The first one, A, is does a sister ship come within the definition of the words quotation marks other forfeit property that's used in Section 2561C of the Act? B, whether the definition of interest as stated in Section 2561C of the Act includes an interest in unpaid crew wages over a sister ship as other forfeit property. So does interest include unpaid wages? C, whether the fishing crew who claim they have unpaid wages are required to have had, and this is a quote from the Sajo Oyang Corporation's Notice of Appeal, prior recourse to and determination of rights they may have had in relation to the vessel under the Admiralty Act 1973, end quote, before they can make an application for relief under Section 256 of the Act in relation to a sister ship. And lastly, the next issue is that were the fishermen required to have previously arrested the ship, the Oyang 75, in Ream, i.e. in the Admiralty Court, and had their wages determined in the Admiralty Court prior to making an application for relief against the effects of forfeiture. So the appellant, the Sajo Oyang Corporation, is in a nutshell submitting that the fishing crew were required to jump through a lot of legal hoops before they could make this claim, that they'd had to have arrested Oyang 75 as an in-rem claim under the Admiralty Act, gone to the Admiralty Court and had their wage claims determined prior to the vessels being forfeited for the fishing crimes before they make their application for relief from forfeiture. I call them legal hoops. I'm submitting that that's not necessary. The Court of Appeal will need to decide that, because that's the whole issue of the case, and whether we can proceed to get wages paid determines whether we're allowed to make it over this ship, really. If the court accepts the Sajo Oyang Corporation argument, then the Oyang 70 crew have no way to get their wages, because they're time banned under the Admiralty Act, because it's been more than 6 years since they worked on the ship, so they can't make an in personam claim anymore. They're under the old legislation, under the old Limitations Act 1950, and they've lost their in-rem options to arrest a sister ship, because they got the sister ships Oyang 77 and Oyang 75 got forfeited to the Crown for these fishing crimes, so they'll just be stuffed. The consequences of preventing the claim would really be financially devastating to the crew, because they just can't get paid, and the Oyang 77, which those crew are allowed to claim over, is just not enough to pay out all the millions of dollars of wages for everyone, because there's just so many crew, and this added up, there's so much wages. The minimum wage was only $12 an hour on 1st of April 2008 to the 1st of April 2009, and then it went up to $12.50 an hour 2009 to 2010, then $13 an hour from 2010 to April 2011, and after April 2011 to $13.50 per hour. That's not heaps of money per hour, but it's just they worked 20 hours a day, and then they were on call during their sleep, and they have to get paid for sleepovers, and plus they're allowed a little bit of an extra top up of an extra $1.25 up to $2 an hour for being foreign fishermen, having to work in these terrible conditions, because it's allowed under the 2006 Code of Conduct for foreign fishing crew. So you add that up and you times it by 680 something days at sea, and all the rest per person sort of thing. It's a lot of money. So we're submitting that His Honour Justice Davidson in the High Court at Christchurch determined the legal issues correctly. His Honour said at paragraph 56, page 29 of his judgment, that he reached the view that in the context, section 256 round brackets 1 round brackets B compels a wide reading. That means forfeit property includes property forfeited to the Crown, which immediately before forfeiture was in the beneficial ownership of the party who, but for the forfeiture, would have been liable under a claim in rem. His Honour acknowledged and said in his decision that the Crown should not receive a windfall profit in such circumstances, because in this case, if the fishermen can't get paid their wages, the Crown gets to keep everything, or they can just give it back to the criminal owners. So in this case, the forfeiture of the sister ship would result a windfall to the Crown of maybe $8 million. And this is at the expense of people who were described by Justice Davidson of not being at fault, because the Indonesian fishermen weren't responsible for these fishing crimes. They didn't cause any of these problems. They're victims. His Honour Judge Davidson said at paragraphs 58 to 60 of his decision of the 18th of December 2015 that interpretation of forfeit property beyond those definitions expressly provided for in section 2561 does not, in my view, do more than reflect the legislative intent that there may be circumstances requiring an expansive interpretation of forfeit property. I consider that the facts of this case provide a clear example. Any other result would in this sense be rewarding Sajo's violations of New Zealand law and the Crown's holding in forfeit. He's meaning the Sajo Oyang Corporation, just shortened it to Sajo. Neither deserves such a reward. The employer's wrongdoing would shield it from liability otherwise attaching to the vessels. The Crown would profit at the crew's expense. The result would be more than ironic. It's against the background of the 2002 Act and one of its purposes, namely to widen the opportunity for crew to seek and obtain justice. The justice of this case compels the opposite conclusion. The wording of Section 256 gives the court interpretive room to manoeuvre where the circumstances so dictate. An extension or contraction of the meaning of a term can be used to prevent a manifest injustice, such as would arise here. Once the context of this case is properly understood, it ought to become clear that the construction given to the statute by this judgment is not heretical. It simply reflects the court's jurisdiction to give meaning to words in the context at hand and to accord with the legislative scheme to avoid a manifest injustice. That's where we're at. That's our argument. His Honour's right. This is other forfeit property. It was property that was forfeited, and it's unjust to allow the Crown just to keep the vessels free and clear without paying the wages where they can pay the wages. Parliament enacted this legislation, 256 of the Fisheries Act, as a matter of public policy, in my submission, to protect foreign fishermen from exploitative foreign employers who engaged in the very behaviour that the Sajo Oyang Corporation demonstrated by not paying my clients the minimum wage. The Sajo Oyang Corporation's argument that there must be prerequisite steps under the Admiralty Act prior to applying under Section 256 would, in my submission, lead to a manifest injustice. It would, in my submission, allow foreign corporations to exploit vulnerable people and to profit by avoiding making payments of the minimum wages under New Zealand law. The Ministry of Primary Industries brought the prosecution to which resulted in the vessels being forfeited. And at that hearing, they opposed the fishermen making an application over the Oyang 75 as a sister ship vessel. In my submission, they are remiss in doing that because they did not consider the Ministry of Primary Industries, the Crown, who is the responsible party in here, are remiss for failing to consider the plight of the unpaid crew members and for failing to consider the wider mischief of this legislation and why it was enacted. It was to prevent the exploitation, the financial exploitation of fishermen, to ensure that they get paid the minimum wage, and that if there are forfeited vessels, that these vessels get sold to pay the wages. That's the whole purpose of the legislation, people. But you would just want to keep the nice vessel, make a bit of profit for New Zealand at the expense of the foreign fishermen that came here on work permits? Yeah, right. We're not having it. In our submission, it's fair that the fishermen be paid for their work and receive the benefit of the minimum wage protections guaranteed to them. Then in my section 2, I go through a narrative of facts in relation to the issues on the appeal. But that, in a nutshell, sort of sets out the basic submission, and then I'll do a separate little video to go through a sort of a narrative of facts relevant to the issues on appeal. So I hope that was helpful.